Hi, folks, and welcome to another episode of Careers and Coffee. I'm absolutely thrilled to be welcoming His Honour Judge Rupert Overbury to Careers and Coffee today to talk to us a little bit more about the role of the judge, the role of the Judiciary, the Crown Court, what's it been like during COVID-19, and getting an insight into his career as well. So we're going to welcome His Honour Judge Rupert Overbury to Careers and Coffee.
Hi, Jordan.
Rupert, how are you doing?
Very well indeed, thank you.
Fantastic. So, I mean, how's things been for you? I'm sure busy, manic, and a little bit strange, no doubt.
Certainly strange, but some people may know this anyway. But the justice system has continued throughout lockdown. We've been coming into work not every day. We've managed each of the judges here about 3 days a week, actually in court, doing court cases, and the rest of the time we've been doing the admin, which has been an important part of keeping things going, and also planning for the future, because we're constantly planning how we're going to get the cases sorted out in the future. Trial, sentencing, people on bail, people coming into court. So it has been manic. It is very strange, but I think the message I want to give to people is that we've carried on, and we are getting through the work, because it's really important that the courts do carry on.
That's fantastic. And my next question to you: have you got a beverage? Have you got tea, coffee? What are you drinking?
No,
today?
I'm dry at the moment. I've coffeeed out before I came on air. So yeah, no, I'm fine. So you just drink away, George. You enjoy yourself.
Well, I mean, look, let's kick off. I mean, firstly, so you are a judge at Ipswich Crown Court. I mean, for folks who sort of maybe see that on the TV, what does that actually mean? What does a judge do at the Crown Court?
Well, primarily, I'm dealing with criminal trials. I mean, that's the main job of a Crown Court judge, and I deal with trials ranging from theft, burglary, through to drugs cases, through to violence of all sorts, ranging from minor cases of violence. I mean, no case of violence is minor, but the less serious ones to the most serious ones. And at the end of, obviously, a trial, if someone's convicted, then we've got to deal with sentencing. If someone's pleaded guilty, then we've got to deal with sentencing. We deal with all sorts of administrative applications that sometimes we deal with on paper, sometimes we deal with them in court. Confiscation cases, so after, say, for example, someone convicted of drug dealing. Oops. See, I should have turned my phone off. I tell people off about that in court. And of course, what do? I get interviewed by Jordan Holder, and I leave my phone on. So sorry about that. So going back to my work, we're kept busy all the time. I mean, most of the work that we've been doing over the last 2 months has mainly been concentrating on people in custody, and about, I would say, 30 to 40% of the people who come through court are in custody. So it's been quite important for us to get those people sorted out. And if it means then them knowing what sentence they're going to be serving, that's a good thing, because it gives them certainty, it gives the victims certainty and finality of a case. And if it means dealing with them in other ways, which puts them back into the community, the probation service is still working. Lots of the agencies are working. So it gets through the caseload and frees us up for the future. But as a Crown Court judge, day on day, I'm dealing with trials, sentencing people, and making sure that the criminal justice system is getting on in Suffolk.
Excellent, thank you for that. And yeah, let's rewind the clocks a little bit to when Rupert was at school. What was school like for you? And did you get any good careers advice? Did they tell you back then to say, go off and be a judge? What was school like?
I never even thought about being a judge until I'd been a barrister for about 20 years. But when I was at school, no, I had very little careers advice, not like it is today, and certainly not the same opportunities that we give people today to come to court, to experiencing it from a young age all the way through to university. So not really a decision I took even to become a lawyer until I was, I suppose, about 18, 19. And then someone said, well, you're a person who likes arguing. I'm not sure whether that was a compliment or not. You may want to think about doing it for a living and being a barrister. And then it sort of flowed from there. And in those days, if you wanted to become a lawyer, you would do a law degree. That was the sort of norm that you would do and you would be expected to do. Today, very, very different. All the students that I see, I always say, do a degree that you're interested in, because nowadays you can convert. It takes you a year, but whatever degree you've done or qualification you've got, you just do a conversion course for a year and then you can go and do the professional exams. So I didn't really have that opportunity when I wanted to become a lawyer. And I became a barrister rather than a solicitor because I like dressing up. As you can see, I've done it for you today. This is the judge's kit. Obviously, a barrister slightly different. There's no fancy red and purple. It's just black with a wig. And it's the theatre that I enjoyed and wanted to partake in. And then after, I suppose, 20 years, I'd done pretty much everything I could, prosecuting and defending, because I did both. I didn't concentrate on one or the other. And I thought to myself, I want a different perspective on the criminal justice system. And I think actually, no, you have. Yes, you have been on the bench with me. It's the best seat in the best theatre in town. And I thought, well, I can do that job. I'm qualified to do it. I've seen both sides, prosecuting, defending, and I was extremely fortunate. It's a long process. It's a longer process today than it was for me 13 years ago, but a fairly long process of interviews and references. And I was very fortunate to be appointed first after my first application. So, and 13 years later, I'm still enjoying it. I'm still getting a buzz out of it. It's different from when I started off. We're doing different sort of work at different pressures, particularly now. But I'm still enjoying it.
And you also mentioned there about the theatre side of things in terms of sort of dressing up. I mean, why do judges, barristers, why do you wear the wigs, for example?
The wigs is simply tradition. And some of us, I for one, just to demonstrate, do have hair underneath. Some judges don't, but that is tradition. It goes back 400 years or so, when the fashion was to wear a wig. And over the centuries, it's been lost to other professions other than the judiciary and barristers and solicitors, because both barristers and solicitors can wear wigs in court. It's not just the barristers. And the uniform that I wear, the red sash that you can see across here, signifies that I sit in the criminal court, in the Crown Court, as a criminal judge. The purple bits to my judicial robe are simply designating me as a circuit judge, which is my level of judge in the Crown Court. If I sit back a bit, these are called bands. It's just an old-fashioned tie with a wing collar that you tie up behind you. And the other thing is, when you walk into a court in another country, everyone's just wearing suits, and some people may find it, other than where the judge sits perhaps, a little confusing as to who's what. There is no doubt when they walk into our courts who the judge is, because A, we're sitting up on a raised bench, but B, we're dressed not like Father Christmas, but we're dressed in our uniform, and people can see who we are. And I think it also lends a certain amount of authority to the job. They can see that you are the judge, and you're in that position above. I can see there's a question there. Can I explain the difference between prosecuting and defending, and which I found most interesting? Well, since we're talking about my career, the difference between prosecuting and defending is that in this country, the prosecution has to prove in a criminal trial that the defendant is guilty. No defendant has to prove that he's not guilty. It's not a defendant's job to prove that they're innocent. So the prosecutor will present the case, trying to prove someone's guilt, and someone defending will obviously do the opposite, try and persuade the jury that they can't be sure, because the expression beyond reasonable doubt or satisfied so you're sure someone is guilt is, oh, he's back again, is...
I come into the office to get better Wi-Fi and it still kicks me out, so there we are.
There we go. I was just explaining prosecuting and defending. We got to defending. The defense would try and persuade the jury that they couldn't be sure of someone's guilt. And sometimes, if you ask yourself about a certain event, can I be sure that that happened in a particular way? Sure is quite a high standard to achieve. So that's what the prosecution has to achieve, and the defense have to knock the case down from that standard. Which I found most interesting. I found both really interesting. I've prosecuted murder cases. I've defended hijackers. It's from different ends of a spectrum. Absolutely fascinating. You need, I think, a bit of both, because I would imagine that would be a question that someone would want to know the answer to. I think you need to prosecute and defend to give yourself an all-round ability in the courts. I don't believe, some people do, but I don't believe that you should just prosecute or just defend. I think to do both is much better for your overall abilities and presentation skills.
And I think as well, just on that as well, you talked about some various different roles in terms of solicitor, barrister, being a judge. Now, if I'm a young person fascinated by law, but I don't want to be any of those, are there other roles across the legal sector for me?
Oh, absolutely. I mean, in the court itself, I mean, it's not just the judge and the barristers in court. There's a huge team of people behind us that actually make it work. I mean, we have admin staff in our general office here who deal with all the paperwork that comes through, and we do generate, even in a digital age, quite a lot of paperwork. In court, I'm reliant on ushers to make sure that the actual operation of the court works. So they will be getting witnesses in and out, making sure that while the trial's going on, that people are where they're supposed to be. They look after the jury as well. That's a really, really important job. Court clerk. I have a court clerk who's on their computer in front of me in court, keeping a record of what's going on. They also process the cases. So if I make a decision and it needs to be processed, so for example, if I send someone to prison, they have to do all the paperwork that generates the remand of someone to a prison. Other than that, you've got the probation service, vital when it comes to sentencing people, particularly young people, that we have all the information relevant to them before we sentence somebody. You've got witness service. The witnesses who come into court have to be looked after. We have a special service that looks after them. We've got security here at court. So the whole court it's a small business where there are lots of cogs to make this big wheel operate. And if we lose a little bit of it, or it doesn't work properly, or they're not working as they should, it doesn't work properly. So just don't think it's just a judge and the lawyers in court. It's not. There's a huge raft of people outside that. I can see I'm being asked for what advice I'd give to an undergraduate who wants to pursue a career as a barrister with the aim to one day sit as a judge. Good question. You can get, first of all, as an undergraduate, you want to pursue a career as a barrister, go and spend some time with a barrister to actually see what it's like. Don't focus on, oh, I want to be Rumpole of the Bailey and just be in the Crown Court. There are lots of other spheres of law where you can operate as a barrister. You could become a family lawyer, you could become a corporate lawyer, banking, sports, entertainment, all sorts that barristers, all those fields barristers work in. If you want to become a judge one day, again, doesn't mean to become a judge like me. It would be better if you had some experience of the criminal courts, but it's not vital that you have to. I know people who are Crown Court judges who were planning lawyers in practice, and then they became a Crown Court judge doing criminal cases. First of all, if you want to be a barrister, spend some time with a barrister. We as judges, particularly at Ipswich Crown Court, offer undergraduates the opportunity to come and sit with us for a day or 2 days. Sometimes, if we can afford the time, as much as a week. You get to sit in the court, you get to sit with the judge on the bench, you get a real feel of what the judicial life is like. So that will give you an idea of 15, 20 years' time. And today we are appointing judges younger and younger because it is becoming more of a structured profession than it was certainly when I began. So get the experience with someone who actually does the job and get a feel for what it's like would be my advice to an undergraduate.
That's fantastic advice. Another question. So what are the biggest upsides and downsides of being a barrister?
Money, probably. People probably don't realize this, but most young criminal barristers are paid less than plumbers. And I'm not, some plumbers are paid a lot of money, but young barristers have a huge amount of expenses. They will have gone through university and done their bar exams, and most of them will have, as with plenty of other people leaving university, quite a debt. As a barrister, you're self-employed, so that's the one big downside. It's also an upside, is that you don't have a regular salary. You are earning what you put into it. So the cases that you go and do will earn your living. So you're not on a salary. You've got to be accountable for your own tax. And if you're registered for VAT, you've got to do your VAT. You don't get holiday money. You don't get paid holidays.
No annual leave.
No annual leave. No, absolutely right. You've got to pay for your own health insurance if you want private health insurance. You've got to pay for your own personal public insurance as a barrister. A lot of expenses. I know that I probably tried in that way to put a lot of people off. I'm not trying to put people off, but you've got to be realistic. You're not going to earn a lot of money for some time, but if you set your heart on it, the upsides are that you're self-employed. So you're your own boss. So if you want to take a month's holiday, you can. If you want to suddenly change and do another sort of law, it's not like being in a company and saying, oh, can I move departments? And somebody saying, well, when there's a space free, yes, you can. As a barrister, you could put yourself out as somebody who specialized in a particular field of law. And obviously, if you were any good at it, you'd get the work. So you're only as good as really your last performance. Reputation is all as a barrister. So it's up to you as an individual to keep your reputation going. So those are the upsides and downsides in a basic format.
And I think just on that, have you read The Secret Barrister, Rupert?
Yes, I have.
I think
that is actually,
yeah.
For anyone who wants to be a barrister, read that book. That is very true. That is just like it is. As I take my hat off to The Secret Barrister, because that is actually a very good book for someone young to read, so that they can see what the pitfalls are, but they can also see what the advantages are.
Yeah, I think, and you read that and you see the level of passion around why, he's not pursuing the financial gains of it. It's more about tackling justice. It's brilliant book. Okay, so next question. So how is a typical case handled from start to finish?
If I whiz us through a criminal trial, it'll all begin one day when I deal with a what's called a plea and trial preparation hearing. So someone will have been arrested for an offence. They will have gone to the magistrate's court. If it's too serious for the magistrate's court to deal with, so for example, it's a case of violence involving a knife where someone is stabbed, the magistrates won't deal with that because their sentencing powers aren't sufficient enough. So it will then be sent to the Crown Court for trial, or if the person pleads guilty in the magistrates, for sentence. Let's just take the example, it's for a trial. Someone says, I didn't do it, I acted in self-defense. It'll come before me or one of the other judges for what's called, as I say, a plea and trial preparation hearing, where that's the first hearing at this court that the person could plead guilty or not guilty. If it's a not guilty, we then set a timetable for trial. That timetable includes everything that me as a judge, and I will have read the papers from beginning to end, which sometimes surprises the barristers, but it shouldn't. And I will make sure that I make orders that are followed so that when it does come to trial, we don't get the situation, oh, we've suddenly thought of something that we want to investigate. We don't want to do the trial today. We want to put it off, which is dreadful for witnesses, victims, police, all the agencies involved. So I try personally to make sure that everything is done at an early stage to make sure it comes for trial. So the plea and trial preparation hearing will probably set the date for a trial, which may be several months ahead. It's quite a long way away at the moment that we're setting dates, but we're trying to be realistic about the dates for trials. Then the case will come up for trial. The first thing that will happen in a case is that the jury will be empaneled. So we'll get in a group of 15, 16 people. We'll pick 12 of them. They will take an oath or an affirmation to try the defendant who's going to be standing in the dock or sitting in the dock. Then we start the trial. The jury will be in court. The defendant will be at the back of the court. The barristers will be on the front row in front of me. And the prosecuting barrister will stand up and will open the case. They'll simply present a very short synopsis of what the case is about and what evidence they say proves the defendant guilty. They'll then call the witnesses, and in turn, the prosecution barrister will ask questions. That's called examination in chief. And then the defense barrister will ask questions, which is called cross-examination. And then whoever's witness it is, so in the prosecution's case, it's their witness, they can then ask some supplemental questions just to make things clear if it's necessary. So we go through those witnesses for the prosecution. At the end of the prosecution case, the defense, if they think there isn't enough evidence at that stage for the defendant to be convicted, can ask the judge to make a ruling in law that there isn't enough evidence for a jury to properly convict and stop the case then. Doesn't happen that often. It doesn't happen that often that judges will stop the case. It happens sometimes because cases have gone through a huge amount of preparation up to that point, so we try and avoid that situation happening. Then it's the defense turn. Now, a defendant doesn't have to give evidence. It's their choice whether they do or whether they don't. If they don't give evidence, they'll be warned that the jury might draw an inference adverse to their case if they don't give evidence. Most people do, because most people, particularly in a case of self-defense, as in our knife allegation, will want to present their case and say, this is what happened. This is what I say happened. You, the jury, should now decide whether you are sure that it didn't happen in the way that I said, and you have to be sure it happened in the way the prosecution said. So we go through the defense case. Defendant might give evidence himself and call some witnesses. At the end of that, the prosecution will then make a short speech to the jury, trying to convince them on all the evidence that they can be sure the person is guilty. Defense will do the opposite. The jury will retire after the judge sums the case up. And that's probably one of the most important parts of the trial, because it's my job to sum up both the prosecution and the defense case in a fair way that highlights the issues for the jury. So in a self-defense case, I would highlight my summing up onto the issue of self-defense, what the witnesses said. So it'd be like describing sometimes a boxing match from different views, and I try and highlight what witness A, B, C, and D said, and then give the jury directions on law. I tell them what self-defense is in law, how the facts in the case apply to self-defense, and give them several other directions, sometimes in writing. I often give juries directions in writing so they can take it out. They then go off to a private room where they are completely isolated. If they take more than a day, at the end of the day, I send them home. And then they come back the next day and they start their deliberations again. And then it's up to them to return a verdict of either guilty or not guilty. They can't give a sort of non-committal or we're not sure. If they're not sure, it's not guilty. Only if they're sure will it be a guilty verdict.
How do you deal with it, though, when a verdict comes back that you disagree with personally? That must be quite challenging, because I'm sure it happens. That must be quite challenging to deal with.
I bite my lip. I tell children, the primary school children who I see on a regular basis, they love, children 9, 10, 11 years, love gory stories. And I once tried a case where a man was accused of trying to murder his boss by chopping her head off with a meat cleaver. And he attacked her once with the meat cleaver, and that wasn't good enough. And as she was bleeding profusely, he then attacked her again. And he was, you may think, quite rightly charged with attempted murder, because what else was he trying to do other than kill her? But the defense said no, we'll plead guilty to causing her really serious harm and intending to do that. We didn't intend to kill her. And at the end of the trial, the very clever defense barrister, who's now the senior judge at Ipswich Crown Court and a friend of mine, managed to persuade the jury that they couldn't be sure, and they found him not guilty. I was pretty astonished by that verdict, but that is the beauty of our system. It's not my decision, it's not my point of view, it is 12 people who have listened to a case very carefully, and they have decided, in their opinion, that the prosecution hadn't proved, in that case, an intent to kill. And that's their job. And I can't argue with it, and I shouldn't argue with it, and I shouldn't interfere. But I can still have my own opinion. And if I do strongly disagree, I keep it to myself. And I smile very sweetly at the jury, thank them very much indeed for their help, and we move on. And that's what a judge should do. Judge shouldn't get involved and shouldn't be partisan in any way.
Blimey. And I mean, in terms of, so, you know, you hear some quite harrowing cases, probably both as your time as a barrister and of course as a judge. I mean, it's a difficult role not to take work home with you. I mean, how do you just switch off from it when you've heard something in court that day and it just sticks with you? You know, how do you just switch off?
Now here's my unashamed plug. I'm a wood turner. In my spare time, I've got a workshop next to my house with a lathe, and I turn all sorts of wooden objects, from bowls to vases to boxes to you name it, I turn it. And if anybody wants to have a look at what I do, I'll take this slowly now. Turning Oakwood is my Instagram page. I don't sell anything. Well, I do sometimes, but it's for charity. I did a charity stall at Woodbridge Christmas Market, and my wife helps me out. That's where I get my release. Be very unfair to go home and rant and rave to my darling wife. I go into my workshop, I do something completely different, turn a bowl for an hour, and that way I'm relaxed and I'm a normal human being. It is incredibly stressful, the job of a circuit judge, dealing with the sort of work that we do. And you need a release valve. And most of the friends that I have as judges have that. You know, some people may just go off into the garden and read a book. Others might, I don't know, go sailing or go for a walk or do some gardening. We've all got our release valve, and we're no different from other people. I'm sure you, Jordan, have got times when it's stressful. You've got something that you go and do, and that's really important. Whatever you do in life, you've got to be able to get away from it at the end of the working day if it's been an awful day. Well, I usually chill out and have a glass of wine. I've got this Instagram page of this guy who turns wood, so I usually have a flick through that. And that's just, well, there you go.
Next question. If you were called for jury service, what is the process of being a juror? And as a judge, can you be called for jury service?
Well, the process of being a juror is well, it's self-explanatory, really. And you will try cases. You normally at Ipswich Crown Court get called up for a 2-week period, during which, if you're lucky, you're going to hear certainly 2 cases. You might just get a third. Sometimes we have longer cases, but we will warn the jury when they come in. For example, the longest case I've ever had to deal with here, I think, was about 14 weeks. But I did say to the jury at the beginning, it had an estimated length of about 12 weeks. But I said that's an estimate and it may go a little bit longer. And surprisingly, but it always surprises me when people are willing to commit to something like that. We maintained the jury all the way through. There were 12 at the beginning, there were 12 at the end. They did their public service. 8 defendants were tried, and I think 7 of the 8 were convicted. And they did a fantastic job, really interesting. They were obviously interested. They asked sensible questions. So that process, juries are selected at random from the electoral roll. So there's a central summonsing office that will send out summonses for jury service to individuals. If you're aged between 18 and 75 and on the electoral roll, you're eligible. If you served a prison term of a certain length, I think it's either 30 months or more, then you're not. As a judge, and that's the next question, it says, as a judge, can you be called for jury service? Yes, you can. And I've 1 or 2 friends who have been. Little difficult, obviously, for me to come to Ipswich Crown Court because all the judges are friends of mine, and that wouldn't work. But they would try and send me to another court. Again, because we live in a rural county, we've only got 1 Crown Court. So I'd either get sent to Norwich, Cambridge, or Chelmsford. It's got to be within about an hour and a half of where you live as a juror. So people in Suffolk can get to Ipswich Crown Court within an hour and a half. So that's the idea anyway. So that's what's happening. Some people get called up more often. I had a lady, she was 72, I think, and had been called up for her 4th time to do jury service. And the last time she'd done jury service, I think she'd served about 5 or 6 weeks. And she said, look, please, I've done my public duty now. I've been on a jury 3 times. This is the 4th time. I'm 72. My husband's not very well. And I said, of course, no, you have done your public duty. And yes, you can be excused. Doesn't happen that often that we excuse people from jury service because, as I said earlier, it is an extremely important public duty that we rely on people performing in order to keep the criminal justice system going. So it's very important. There aren't that many reasons to be excused, and I wouldn't get excused.
Excellent. I'm going to come up to sort of the last few questions because I appreciate we're running over a little bit. The next one that's just come up. So do you ever get nervous when you know you have a big court case approaching?
I won't say nervous, but because I've been involved in the criminal law now for 36 years or something like that, long time. And it doesn't make me nervous, but sometimes I get slightly apprehensive. I want to make sure that everything's right, that everything's in the right place, that people know what they're doing, what's expected of them. So in a big case, there are plenty of hearings in advance of the trial day that I can use to make sure that happens. So actually on the day itself, no, I wouldn't say I'm nervous. I'm still a little apprehensive that everyone's going to do their job properly and that we can get on with it. Because the last thing that we want, and particularly these days, now that we're going to start jury trials again, is that a jury comes in and the trial isn't effective. No, we've got to make sure that if we're asking people to come in, particularly in a pandemic, to try a case, that we're ready to go and everyone knows what they're doing. So I think probably when I start, I think that I've got a trial possibly due on week after next. I probably will actually then be a little bit nervous for the first time in a long time, just because I want to make sure it's right and that people aren't kept hanging around.
It's the middle of a pandemic, so I'd understand that. I mean, what's the strangest thing to ever happen in your courtroom?
Well, in my courtroom, didn't happen to me, but the judge who used my courtroom before me was attacked. And again, shouldn't have happened. It was just one of those things. Someone ran from the public gallery, managed to get up the steps onto the judge's bench, and just as he was getting away, managed to knock his wig off. Extremely serious offence, dealt with by another judge very swiftly a couple of days later, and the person went immediately to prison. Strange in the sense that A, shouldn't have happened, but B, in my career, I think I've only ever heard of that happening twice, if not three times. And you think of the number of cases that are going on day in, day out. So that's extremely rare. The other strange thing is my wife came to watch me with a friend of hers, and I didn't tell the court staff that she was in the public gallery, and she was making some notes and looking up at the jury and making notes. And I don't know what the usher thought that she was doing wrong, but when I had a coffee break mid-morning, I was going to call her in and come and join me for a cup of coffee, and the usher went over to her and said, "I don't know, madam, what you think you're doing, but you're creating in my court." And one of the barristers came over to him and said, "I'd be careful if I were you. That's the judge's wife." So strange for her, not strange for me, but there we go.
Blimey, that is interesting. And what have we got there? Has the law changed since you become a judge? So I know that you were called to the bar in 1984. So I think two questions here. You know, what's changed since then, and why is it called the bar? What's the bar?
Well, being called to the bar, there are 4 Inns of Court that's still going. It's very a sort of ancient system. But being called to the bar is simply being called as a barrister. You take effectively a second degree. So after whatever degree you've done, and then you've taken the exams, the barrister's exams to qualify as a barrister, you then get called to the bar by your particular inn. So you are called as a barrister. Law changed. Lots of laws have changed since 1984. We've got a brand new Sexual Offences Act. We've got lots of things that have changed. Proceeds of crime. We've modernized the whole legal system so that it's more difficult now for criminals to get away with their ill-gotten gains. So for drug dealing, fraud, and things like that, there are lots of processes by which the state can recoup any benefit from their criminal conduct. In court itself, we've got lots of new rules. We've got criminal procedure rules, criminal practice directions, which are formulated by more senior judges, particularly the Lord Chief Justice, which make for more efficient running of the courts. And what we've tried to do, certainly in my time as a judge, is to make it more efficient so that it's the cases are effective, that it's more user-friendly. I mean, nowadays, one big thing that we have learned, I'd say, from COVID-19 is the ability to use at very short notice any technology that's available. Skype, Microsoft Teams, Zoom. I had a police officer the other day who was making an application, a private application to me, but I'm in court. It's all being recorded, but there's no one else. It's just me and the police officer and members of the staff. And obviously they can't come into court. Well, they don't come into court necessarily for that sort of hearing. And Skype wasn't working. So I said, fine. I said, you got an iPhone? She went, yes. And we're doing this over the phone. I said, because I've got to see your face and we've got to be able to record this. I said, just use your iPhone, FaceTime me. So she FaceTimed my personal mobile phone, which is all being, again, the sound's being recorded. So in order to get things going, we've used all sorts of technology. And I hope, and I truly believe that as we go forward out of this pandemic, that sort of technology we can continue to use to make court cases more efficient, quicker in the sense that they will be more efficient, and hopefully that if people don't have to come to court, they don't have to, and we can deal with applications or some cases evidence. It's not always the case for a witness that you can deal with them away from court. the best place for them to be is in court, so the jury can see them and assess them. But there are circumstances where we can use remote technology to allow someone to give evidence from a police station or their home or hospital or something like that. So I hope that we use that, and I think we will, which should speed up the process at the end of the day.
Excellent, thank you. And yeah, there's going to be a lot of young people who are getting their GCSE and A levels next month, and I'm sure they are quite nervous about the next steps that their pathway is going to take. Yeah, what's your advice to those young people who are a little bit concerned about what the future might hold at the moment?
Well, I think they've got to be positive. I think we've all got to be positive, and it's not carry on as normal, because we can't carry on as normal. But they've got to maintain that positivity. They've got to maintain their determination. And if they've set their sights on doing something, you can still do it. Whatever you want to do, you can still do it, because everyone is trying to make business work, trying to make the courts work, even sports, even though there aren't spectators there, it's still working. So, if you're a sportsman, it can happen, and this won't last forever. It is going to last, a bit longer, and let's hope that there are things that will be put in place, antibody tests, vaccinations, whatever, that will make life a lot easier. But stay determined, stay positive. Anyone who's determined and positive will succeed in life. That's my advice to them.
I think that's a brilliant way to end. That was some fantastic advice, Rupert. So just a huge thank you for coming on to Careers and Coffee today. I know you're an exceedingly busy chap, so I'll let you get on with the rest of your day. But yeah, thank you so much for coming on.
Jordan, pleasure to talk to you, and I look forward to seeing you in person soon, I hope. Bye for now.
Looking forward to it. Thank you.
Okay.
So folks, that was His Honour Judge Rupert Overbury of Ipswich Crown Court, giving us an insight into his amazing career, some of the weird and wonderful things that have happened in the courtroom, his life as a barrister beforehand, and also what a judge currently gets up to during coronavirus as well. So huge thank you to Judge Overbury for coming on to Careers and Coffee today. So this is one of the final weeks of Careers and Coffee. So next week we actually have on 3 judges on Tuesday for a panel debate between them, to talk a little bit more about the judiciary and the sector as well. So tune in on Tuesday, 12:30 till 1, to hear a little bit more from them. And then on Thursday, I think this is probably going to be one of the best ones we've ever had, because it's myself and Josie, who people assume that I just go on to Careers and Coffee and that I do all the wizardry behind the scenes, but Josie is there behind the scenes, doing everything for us. So she's going to come on with me, and we're going to have a chat. We're going to have a coffee and talk a little bit more about our best bits of Careers and Coffee. So tune in for that next Thursday, which will be the final of our first season. So looking forward to seeing you then. Thanks.